On January 30th, the Department of Justice released more than 3 million pages of records, 2,000 videos, and 180,000 images, all tied to Jeffrey Epstein. Within only a few hours, photographs emerged depicting a man who appears to be the former Prince Andrew kneeling beside a woman on the floor. But those images, while shocking, are merely the surface. They dominate the headlines, yet they are not the real narrative. The true story lies hidden in what the Department of Justice chose not to disclose, and from a prosecutorial viewpoint, that omission is exactly where attention must be focused. At this moment, the most powerful justice system in the world has informed Congress that it has fully satisfied the legal requirements, and Congress is already challenging that claim because the numbers simply do not reconcile. To understand why this matters, the timeline must be examined carefully, because context defines everything. In 2005, the Palm Beach Police Department initiated a 13-month undercover inquiry into Jeffrey Epstein after a parent accused him of sexually abusing her 14-year-old daughter. By the conclusion of that investigation, law enforcement had identified dozens of victims, including girls as young as 13. The case was transferred to federal prosecutors, specifically the United States Attorney's Office for the Southern District of Florida, which at the time was led by Alexander Acosta. His team constructed what should have been an overwhelming federal prosecution. A 60-count indictment was prepared, and 30 victims had already been confirmed. The Federal Bureau of Investigation continued its work, yet Acosta abruptly ended the case. In 2007, his office entered into what later became known as a sweetheart agreement, a non-prosecution deal. Epstein did not face federal sex trafficking charges, but instead pleaded guilty to 2 state-level prostitution offenses in Palm Beach County. He received a 13-month sentence under work release, allowing him to leave jail for up to 12 hours a day, 7 days a week. Consider that reality: a man accused of abusing dozens of minors, some barely teenagers, serving a sentence largely outside prison walls. The situation grew worse when that agreement granted immunity to Epstein's associates, concealed its terms from the victims, and effectively terminated the federal investigation. A federal judge later determined that this arrangement violated the Crime Victims' Rights Act. The Department of Justice's own Office of Professional Responsibility concluded that Acosta had exercised poor judgment, yet no criminal accountability followed. Years later, in July 2019, federal prosecutors in the Southern District of New York, under Jeffrey Berman, brought new sex trafficking charges against Epstein, this time seeking the full weight of federal punishment, potentially 45 years in prison. 6 weeks afterward, on August 10, 2019, Epstein was found dead in his cell. The official cause was ruled suicide, and the prosecution effectively ended. However, what is often forgotten is Berman's statement at the time. He declared that the investigation into the conspiracy and the wider network was still active. That word conspiracy was deliberate and legal in nature, signaling that authorities were examining other individuals beyond Epstein himself. This brings us to January 30th, 2026. The Epstein Files Transparency Act had been enacted by Congress in November 2025 with overwhelming bipartisan support. It mandated that the Department of Justice release all federal records related to Epstein and Ghislaine Maxwell within 30 days. The department missed that deadline, citing the sheer volume of material, 6 million pages, and the need to review and redact sensitive victim information. On January 30th, Deputy Attorney General Todd Blanche held a press briefing announcing the publication of more than 3 million pages, 2,000 videos, and 180,000 images. He stated that this disclosure marked the conclusion of the process and that the Department of Justice had fully fulfilled its legal obligations. What has not been openly acknowledged is that the department itself identified 6 million pages as potentially responsive. Approximately 3.5 million pages were made public after redactions, which means nearly half of the total material remains undisclosed. Deputy Attorney General Blanche offered several explanations for this decision, citing the protection of victims' privacy, the presence of child sexual abuse material, ongoing investigations, and attorney-client privilege. These are valid legal categories, and that is not in dispute. However, the situation becomes troubling when examined more closely. The very next day, the House Oversight Committee, led by Democrats, issued a formal letter noting that the Department of Justice itself had identified more than 6 million responsive pages, released only about half of them, and then declared that it had fully complied with a law requiring the release of all unclassified records. Representative Robert Garcia, the ranking member of the committee, stated bluntly that the DOJ was withholding roughly 50% of the Epstein files while claiming total compliance, calling the situation unacceptable. Representative Ro Khanna, one of the primary authors of the Transparency Act, echoed this concern, saying that the failure to release the remaining documents serves only to shield powerful individuals who may have been involved. From a prosecutorial standpoint, this discrepancy is critical. When a statute mandates full disclosure and the executive branch releases only part of the material while asserting completion, that is not true compliance, but rather a negotiated outcome. And the obvious question becomes, what is contained in the withheld portion? Even the material that has been released is explosive. Among it are photographs of Prince Andrew, identified as Andrew Mountbatten Windsor, kneeling over an unidentified woman on the floor. Her face has been redacted by the DOJ. In one image, he appears to be looking directly into the camera, while in others, his hand rests on her abdomen. There are no captions, no dates, and no location details, and the Department of Justice provided no explanatory context. Alongside these images are emails from an account labeled as the Duke, exchanging messages with Epstein. In an August 2010 exchange, only months after Epstein's release from home detention under the earlier non-prosecution deal, Epstein offers to introduce a 26-year-old Russian woman for dinner in London. The response says he would be delighted to meet her and asks whether she will bring a message from Epstein, requesting his contact details. In a separate exchange from September 2010, the same account proposes dinner at Buckingham Palace and adds the phrase, "lots of privacy." Mountbatten Windsor has repeatedly denied wrongdoing, settled Virginia Giuffre's lawsuit for an undisclosed amount without admitting liability, and was stripped of his royal titles by King Charles in an effort to distance the monarchy. Yet the central legal issue extends beyond Andrew alone and points to a broader pattern. The files also mention Commerce Secretary Howard Lutnick planning a visit to Epstein's private island in 2012, email correspondence between Epstein and Elon Musk, and references to filmmaker Brett Ratner, Sweden's Princess Sofia, Denmark's King Frederick, and Norway's Crown Princess Mette-Marit, whose name appears hundreds of times in the released material. Among these documents is an internal FBI memorandum dated August 2019, just 5 days after Epstein's death, listing 9 individuals identified as his family members and associates, with 8 of them labeled as co-conspirators. Most of their names and images remain redacted. Only Ghislaine Maxwell has ever been formally charged. That number matters. 8 alleged co-conspirators. Acosta's 2007 agreement granted immunity to co-conspirators, and while Maxwell was convicted in 2021, and the Supreme Court declined to hear her appeal in October 2024, her conviction stands alone. At least 7 others have never faced charges. This points to a failure that spans multiple administrations, prosecutors, and institutions. Legally, the next step is unfolding. The Oversight Committee has issued a subpoena to Attorney General Pam Bondi, demanding the complete unredacted files, which has not yet been satisfied. Senate Minority Leader Chuck Schumer has publicly questioned whether every document referencing Trump has been released and whether all co-conspirator memoranda have been disclosed. Deputy Attorney General Blanche rejected claims that the DOJ protected anyone, insisting that there was no White House involvement in the review process and that any evidence of abuse by others would lead to prosecution. Yet this assurance is undermined by the fact that half of the documents remain withheld. It is not credible to promise accountability while simultaneously retaining millions of pages from public view. From an institutional perspective, this history should alarm every American regardless of political affiliation. In 2007, a federal prosecutor had sufficient evidence to pursue a major sex trafficking case, and instead negotiated a deal that protected co-conspirators and silenced victims. In 2019, a new prosecutor revived the case, and the defendant died before trial. In 2026, Congress passed a transparency law with overwhelming bipartisan support, and the executive branch now claims compliance while withholding half of the responsive material. At each stage, powerful figures were shielded from responsibility, while victims were not. Virginia Giuffre, whose lawsuits brought much of this into public view, died in April 2025 without seeing anyone besides Maxwell held criminally accountable for the harm done to her and many others. This is what institutional breakdown looks like. It does not occur in a single moment, but through a series of decisions. One deal at a time, one redaction at a time, one missed deadline at a time. The pressing question now, one that should trouble every prosecutor, judge, and lawmaker, is whether anyone within this network will ever face genuine federal accountability. The documents that have surfaced reveal connections, relationships, and a pattern of conduct spanning decades and multiple countries. But a network only matters if it is prosecuted, and prosecution requires political resolve. That resolve has consistently been absent. At present, 3 million pages have been released, with hundreds of thousands posted online without an index, table of contents, or explanation of how each document fits into the broader investigation. The Oversight Committee is demanding the remaining files, lawmakers across parties are raising concerns, and the public is watching. Yet observation alone is insufficient. The Epstein case exposed something far greater than the crimes of one individual. It revealed a system in which wealth, political influence, and institutional deference allowed years of abuse to continue with minimal consequences. The non-prosecution deal, the sealed agreements, the defendant's death, and the withheld records were all decisions made by people who had the authority to act differently. The victims, the young girls, and women who were abused bore the cost of every one of those decisions. As this investigation continues, and it will, the most important response is to remain informed, demand explanations from elected representatives, and hold every institution involved accountable for what it knew and when it knew it. More truth and more accountability must follow. This story is not finished.